Hey, everybody. My name is Al Nicoletti. I'm an attorney here in Florida. If you don't know me, I do all these different kinds of things. I do probate, partitions, quiet title, trust stuff. But I teach on this kind of thing frequently, and I'm bringing it to you once a month. So on tonight's episode, I'm bringing you Florida Trust, solving trust title issues. And I'm not talking about trust title issues in terms of closing and that end on the underwriter side. I'm seeing it from a different perspective from the underwriter side, trying to help solve the issue about why it's not closing because something's really messed up with the trust. So what I'm diving into is not closing stuff. It is not any of that kind of title work, but it is things that are used to help get it done, get it to closing, help the whole thing move forward. So it's a really different kind of strategy. It's a different kind of. It's not probate, right? So it's not as frequent actually as probate at all. It rarely comes up, but it does come up enough that it becomes a topic and it becomes an issue on title. And we'll talk about that. We're going to dive into it. So again, welcome. If you have questions, wait until the end. But drop them in as we go, and I'll cover them at the end. But wait. We'll get to it later, but please share your experience, drop your comments, and dive right in. I'm Al Nicoletti, and you can find me on Facebook at Al Nicoletti. I have a YouTube channel, so if you want to go onto the channel, I got content on probate. I'm going to bring in more on quiet titles, partitions, the trust administration. Also, I'm going to be rolling out soon. This is actually the first time I've talked about it, but I'm going to be rolling out my new podcast, Al Nicoletti Show, and I'm going to be having tons more content, full long podcasts on there that you can check out. And sure, I'm going to be posting little things on Facebook as we go, but check out the channel. It's there for people to like, subscribe. Most importantly, every investor, every realtor, everybody that deals with real estate always goes through a very different theme and experience. I realize that every time that somebody will have a similar question, but focus on different themes of either probate or trust stuff. So those are really good videos that may touch upon something that you are going through right now. It may not be something down the road, but maybe now or maybe down the road, and it sparks something in you that goes, oh, that's where I saw it. I saw Al talk about that. So check it out. But today I'm going to make it, I really want to make this segment watered down, parsed down, really easy to understand, because Florida trust and title issues involving trust can be really complicated, and you don't have to know everything. Just like probate, right? You read the books, they're all over the place. They talk about way too many things. You read the online things, talk about way too many things. You don't need to know all that kind of stuff. So I'm going to break it down, and you'll see the deeds, you'll see kind of the property appraiser stuff, but this is such a unique area that when you come across that lead, you come across the motivated seller, you come across it on a list or something that you pull. We're talking about Florida, but you pull it on a list and you see something about a trust and there's issues with it when you go to closing or you get your title commitment. That's where this plays a role. And it's not that you have to know exactly the strategy. You just have to be able to issue spot. So I give my legal disclaimer all the time when I do these presentations, and I say this PowerPoint presentation video does not provide legal advice, nor does it create any attorney-client relationship. That the matters discussed in this presentation video are informational and educational only. So you're going to enjoy this. There's going to be a lot of content in here. And just the key points I'm going to talk about: solving trust situations for real estate, which is going through and how do we solve some of these things as they pop up, trust administration stuff. That's what this is. It's like probate administration. They don't call it probate administration. They just call it probate, but it's administering it and trying to help move it forward to a conclusion and distribute and do what the trust says, do what the document that was created by that person says. And that's the whole point. And two really big things we'll talk about that pops up whenever you find a deal or you find a situation where there's a motivated seller, but there's a problem. Maybe the trust is lost. So the property's titled in a trust, or the deed shows it's titled in a trust, but the trust is missing. what do you do? I mean, do you just let it go? Is it something that is it worth salvaging? Many people don't know about what to do, and sometimes a lost trust happens. Rarely happens, hard to find too, even in my world. But successor trustees is a really big thing, and we'll talk about this because when you come across that lead and you're like, oh no, what's next? What's this? What's that? Many title companies will pull the title and go, oh, this is a different thing. How can we help solve it? What do we do? So there's just key points today, because at the end of the day, all this is about, all of it is about satisfying title insurance. Because in order to close, title insurance wants these things done. They want a court order that's going to line these things up. They're going to want to see all of the things that are required, that people have authority to sign these documents, the deeds, all of it. So it's all about satisfying the title insurance. So what I'm not covering today is land trust. It's just not something we're covering. We're not talking about drafting. This whole segment's not talking about drafting or creating trust or putting them together, what goes in a trust. We're not talking about like revocable trust contents. We're not talking about taxation or anything that happens with whether I do an irrevocable trust or revocable trust. The whole point of this episode, this show, is to cover the weird things that happen when you find a motivated seller and the property is titled in a trust, but something is messed up. Something is really weird and it won't close. Title insurance says it's not going to close. That is what we're talking about strictly today, because these issues come up and prevent a sale. At the end of the day, the sellers and buyers want to close. Everybody wants to close, but these little trust things can hold up and block the closing from happening because it's just all strange. So we're not going to talk about all the extraneous stuff. And I bring these trust things up because many of you have seen this on my PowerPoints before. It's because we're getting to a point where you're going to see more of these trust properties pop up. People are accumulating wealth. People are trying to find asset protection. So they're putting a lot more of their properties into trust to help protect or do whatever they want, or it helps with tax benefits. You find a lot of the properties maybe in more affluent areas, but not necessarily. You can find them anywhere. But a lot of people that have wealth usually do these trusts. So you're going to find so many people that have this money, the baby boomers, right? The baby boomers have this money and they're accumulating it and they create this trust. They die. And then they leave this trust, the properties in a trust, the bank accounts in a trust, a brokerage accounts in a trust, so many of these things. And you hit the silver tsunami. You hit the point where the baby boomers have all of this wealth. They left it in all of these documents and they've titled everything that way to help protect. And they don't want to make sure their children spend all of the money. So they make sure that it's distributed over time, or there's so much money that they're going to get hit with the tax bracket. So we head to this point. I tell you that you're going to see it happen more. And this part is not about understanding everything. This is not, we need to know everything about this because I need to explain this to a motivated seller. It's not. Anytime you see this, it's all about issue spotting. The red flag goes up when you come across these. You're not thinking, how do I do this myself? Or this is exactly what happens, because you never know. Everything needs to be evaluated as it goes. And it's just truly all about what you see and how you issue spot it. And it's coming across these real estate. I could bet that so many people that will eventually watch this will find that they've come across many properties titled in a trust, but something's messed up and they don't know what to do. Seen about 4 of them before, but they're really crazy. So where am I going though with this? So you find this property, that's how it's titled in the property appraiser, right? And let's just say, for example, it says John Smith Revocable Living Trust. Great. You found it because you used your list, you did your skip trace, you found out this property, Main Street, is in a trust. So if it's in a trust, then you know that something about a document's been created. Maybe there's beneficiaries. So you dive a little bit deeper. Maybe you want to check the deeds. Some people do check the deeds. But you check the deeds and you find out, oh, there's a quitclaim deed, right? There's a quitclaim deed and it says John Smith as trustee or successor trustees of this revocable living trust. So you know the property's titled in a trust. So you come across this kind of lead, you do your skip tracing, you find out Betty is the beneficiary and she agrees to sell. She's the only beneficiary. Let's just say, for instance, there's a trust here. So you look in the trust, but no trustee is named except John Smith. And you bring it to title, and title's like, oh no, what do you do? So this is the kind of situation I'm looking at, where it's titled in a trust like this and you find a motivated seller. So you go to title, right? Everyone should do their due diligence in getting title. Title insurance is important, but getting your title search and title commitments up front, right? Because everybody wants to know what happens up front. Everything is much better knowing what's happening. So if you get your title commitments, the title commitments will tell you what's happening. But better yet, the title commitment, just like probate will say proper probate proceedings required. For trust, it'll say something about an order of successor trustee required, or an order, a declaratory judgment establishing a trust required, right? So you pull this title because it shows you bottom line insurance underwriters telling you what you need to do to close, what you need done, what has to happen here to issue a buyer's insurance policy. And real estate trust issues, when it comes to this stuff, varies. So when you find that happens, sometimes it's because when someone dies, if they have a revocable trust, upon death, now the trust becomes irrevocable. So if there are issues that are involved that need to be resolved, sometimes the court has to get involved, right? So sometimes in order for those issues to be resolved, you go to court, because in trusts, just like documents, just like contracts, there could be missing terms. There could be ambiguous terms. There can be things that are not covered that should have been covered, just like a contract. Trust have those same kind of things, just like a will. It's no different, but trusts have issues, just like no successor trustee appointed. So only John Smith was named. Nobody else was named. That could be, that's a problem, because if that seller beneficiary ever wants to sell the property and close, it's not closing until somebody's named. Or better yet, what happens when beneficiaries are fighting and don't want to sell? Maybe it's something that needs to go before a court to address what happens at that point. That can happen as well. But the main issue that happens with these trusts, and you're thinking, oh yeah, Al, you've talked about this before. You said that trusts avoid probate. That's true. But poorly drafted trusts do not avoid some type of court administration. And that's important, because it's just like probate in a way. You're doing some kind of thing to help move the case along, distribute the assets, make sure everybody's entitled to it. But just because a trust avoids probate doesn't mean that the trust doesn't avoid some kind of court administration, some kind of court proceeding that actually happens, because title insurance requires it. Title insurance will say, there's something wrong here. There's something that has to happen here. So what are we doing? What do you need to do to get this fixed and done? And so we run into these situations because every time you have a trust, there's a trust, you have a trustee. The trustee has authority to act on behalf of the trust to do things for the benefit of the trust. So many duties and things that we can cover that are laid out for a trust. But there's these duties for a trustee. Then you have beneficiaries, you have successor trustees, and you have the actual trust document. So, and I talked about this, a trust avoids probate, just like some of these other things that avoid probate. But I have this slide up usually. Trusts avoid probate, but poorly drafted trusts do not avoid probate. And that's very important to know, because for some things like irrevocable trust, again, if it's irrevocable while the person's alive, they cannot change that trust without the person that created it, the beneficiaries, and usually the court to change any kind of issues with the trust. So maybe the term, the length of the trust, things like that, they require court intervention. But and you're probably thinking like, this is crazy. You did your estate planning. Are you telling me that just because we did our estate planning, now my children, grandchildren are not going to have to avoid some of this stuff, or they're gonna confront it? And it's yes, because some things in trust need a court to overlook it. That document's really complicated, and especially with title insurance. Title insurance dots their I's and crosses the T's, and they want to know, does that person that's named in a trust have authority to sign the court documents? When we do distributions not me at a closing, I don't do closings, but I'm saying it from the perspective of an underwriter. From the underwriter's perspective, they're saying there's no trust. What if it lost trust? They don't have a document to say who are the beneficiaries. So you have to do some kind of court proceeding to help get or lay a new trust, establish a new trust, or to help now appoint somebody that can sign the seller's docs or the closing documents or the deeds at closing. It just ends up being really important. People overlook some of these small things. You got a contract, but you forget about the underwriters usually looking for somebody with authority. I thought about this before I came on. Great example is like probate. With homestead property, all of the heirs, or in that line, all the true heirs sign, so they have the authority. They are the true heirs, homestead property. But let's just say you're looking maybe at land or secondary property where you could have a personal representative. That's like a trustee, right? That personal representative has authority to sign, just like a trustee. But they have to have. They are the ones that title insurance is looking for. Again, I'm not spewing words to help make sure you understand every single thing, but you're issue spotting in a trust problem. There are trust issues that come up from time to time, and you wouldn't believe how much they come up. They do come up. So sometimes the reason we even have this administration or this trust issue, because it is a complicated topic, is sometimes maybe the trust was too short, and in order to make sure it's still in effect, and that it doesn't revert back maybe to the way it was to title, or you have to have a probate or some kind of issue, you can lengthen the term of the trust. Or sometimes, like in number 2 there, the underwriter may want specific language changed in the trust to help a loan. We've seen that before. You have times where an underwriter wants the provisions changed about distribution because how distribution was supposed to happen wasn't in there. I think it left out like whether it was up to 30 years old or 35 years old, but everybody was younger. It was really strange. Somebody didn't contemplate poorly drafted trust. Somebody didn't contemplate what was to happen upon death. So they had different distributions. So the underwriter needed it before getting that loan. Or changing the identity of the trustee. Maybe the name's messed up. We'll talk about Scrivener's error. Sometimes a successor's not named. That's where you can do all the estate planning you want. So for people that have ever thought, oh, I still need to do my will, I still need to do my trust, I still need to do my POA, power of attorney, all that stuff. Just because you do your estate plan, you need to make sure that it contemplates multiple steps changing. That's why you're always asked at those sessions, those consults, who do you want first? Who do you want second? What happens with second dies? Or resigns or becomes incapacitated? Who do you want third? Because if you have a line of succession, you've contemplated what happens, but you wouldn't believe how many people have done estate planning documents where they don't contemplate what happens. Or I'll show you, they name like a company, right? But the company's only aim is, we're going to do this only if there's like $1 million. Okay, so they put the property in the trust. It's like 150,000. Now they don't want to serve, but nobody else is named after them. It doesn't contemplate what happens. So the poorly drafted trust causes an issue for title insurance. And sometimes beneficiaries have a difference of opinion. Sometimes they don't get along. Things like that happen. What do you do? Maybe the trust needs to be changed. And like it says in number 6, divided to multiple beneficiaries, it needs to be distributed in a different way. But there's reasons that we have to do this stuff and that this pops up. And the main one is the successor trustee. Because if there's somebody named, it doesn't mean they have to serve, right? If there's a trust and there's a trustee named, just because they're number 1 in position does not mean they have to serve. They can decline to serve, and they could resign. They could maybe not be qualified. There may be issues about they died, incapacitation. They're mentally not there, so they can't. And that's why you look to number 2. So there's reasons that there could be a successor trustee. That's why you saw the one with the John Smith trustee. John Smith was the actual person that created the trust. So if he dies, there has to be somebody next in line. So there's other reasons. Maybe somebody was removed because they violated a duty. There's so many duties to preserve, duty to protect, all of these different duties about being a trustee. They weren't doing it correctly. So there are different ways that a trustee is appointed and maybe knocked off. Because if they're incapacitated, they can't sign the documents. Title insurance definitely not going to want that. So there's different ways that a successor trustee could be built in, and it's good to have multiple trustees so what would happen next. It's just one of those things that is really important. And they usually look to who's next on the trust. And usually you look to the beneficiary to see who agrees, right? So if you have that situation, it's almost like probate. Does everybody agree that this person can now sign on everybody's behalf? It's almost like that, right? So you're looking to get somebody. If somebody doesn't want to serve, they resign, they're dead, they're incapacitated. It's all about somebody that has authority. So this is one that happened. It's basically an example of one that I've seen before, right? So the property was titled in a trust. So investor comes across this property. It's titled in a trust. The guy died many years ago, for like 1990, many years ago. And in the trust, it only named him as trustee, and then it named the trust company as a successor trustee, meaning if Jack Smith dies, the trust company is next in line to serve as trustee. That doesn't mean they want to serve. It's just they're named. They don't have to do anything. They could resign and say, I'm out. But if they're named as the trustee, they could elect to serve. But in this case, they didn't want to serve. And there were like 3 or 4 beneficiaries. So they said, we don't want to serve. The company sent a resignation letter. And the next thing you know, they go to the title company, they get a title commitment, and the title commitment says trust order, an order of successor trustee. They wouldn't close, the title company and the underwriter wouldn't close until there was that kind of order. So if you look, this is how it came back. On number 4, on the commitment, it came back as title to the fee simple estate was vested in successor trustee, and then it names Jack Smith, but he's deceased. So it says titles in a successor trustee. Nobody named, 0. There's nobody named. That's not an individual. That's not somebody that can sign. So the first thing you're thinking is, what was that thing that was discussed here? It's talking about if there's a missing successor trustee. Now you're thinking, oh boy, there needs to be this kind of court administration. It's like probate. It's not probate. Yes, it's in probate court, which is funny because it's not probate, but it's in probate court. But it's not probate. It's just administering it. And so the deed actually, that's what the deed said on the bottom, Jack Smith trustee. But again, this is an example of what happens when there's no authority to sign. And the trust company just did not want to serve. It's all about who has authority to sign the documents. Just like heirs in a homestead property, just like all of those situations, if the heirs all sign on homestead, they all had authority to sign. So what happens in this case? It's all about authority, because an underwriter does not want to take the risk on somebody or the 2 beneficiaries just signing when a trustee is charged with overlooking the trust. They have that role of overlooking the trust. So they are the ones that has the ability to sign the documents. Very, very big point here, because it's just so different than probate. You have a personal representative in probate. You don't always need to have a personal representative. Had that question the other day. You don't always need a personal representative in a probate. Usually they're just petitioners. So when you have this scenario, it's almost like a personal representative with authority, but it's not. There's nothing there. Now, lost trust. This is kind of interesting. Rarely happens, but it does come up. Sometimes property is titled in a trust, just like we saw. Property's titled in a trust, but the trust document is gone. There's no copies. There's nothing saved anywhere. And an abstract of trust is not a trust. That's like the Cliff Notes version of a trust. It's not a trust. But the trust is lost, the actual original document. Even if you have a copy, it's good. We'll talk about that. But what happens when you approach that beneficiary? They claim to be an heir. They claim to be the beneficiary for the person that owned the property. But there's nothing. There's no document. It's not like probate where, oh, okay, there's no will, so we're just going to look at the intestate statute. No, because the property's titled in a trust. Obviously, before that property got titled in a trust, somebody signed some kind of trust document. And if there's a trust document, that presides over who gets the distributions of what happens. So what a underwriter is looking for, you'll see it come back, or if the title company shows you, you'll see it. If not, it's on the title commitment. So it'll say something about needing the appointment or a DEC action, a declaratory action, to reestablish a trust. Yes, that means taking a bunch of stuff and creating a new trust that probably looks something like the trust that was lost. It's possible to do. Seen it on some things where they require so many affidavits. They want like documents from the estate planning attorneys, but sometimes it happens. It can happen more often than you think, because maybe they lost it in a fire. Maybe one of the beneficiaries is hiding the ball, so they don't want everybody to see because they're out. So maybe they just took it and ran. But I'm talking about zero trust, nothing but properties titled in a trust. And this kind of proceeding that an underwriter would want to create a new trust out of thin air. This is not creating a new trust because we know what was in the trust. This is creating a brand new trust in a way, using a whole bunch of documents and affidavits to recreate a new trust, to appoint a trustee to then sign documents at a closing. Crazy. I mean, it's crazy that happens. Copies of lost trusts, well, it can't be lost if you have a copy, right? But the original trust, photocopies can be allowed. So as long as there's some kind of evidence that there could be a trust, at least at least you've asked and said, is there a trust for this? And oh, there's a photocopy. Well, great. At least there's something that talks about what's happening, because otherwise you don't even have a clue. Or something that talks about whether they are a trustee or not. If they are a trustee, great. I mean, do they have the authority to sign? Who are the beneficiaries? Do they all agree? Are you going to be able to get waivers from everybody in the trust administration? But bottom line is that the trust is going to talk about who are the beneficiaries. You can't make this deal happen if you don't know who's involved. The trust is, there's been times where you can see a trust and it'll say one beneficiary gets the proceeds of the house, and then another beneficiary gets the proceeds from the sale of the personal property, the furniture, the car. So that's why having those trusts is really important, because what if that person changed or specified where those assets were going, and nobody really knows? Nobody knows what was really in there. So at least there is some kind of copy of a trust. That's just helpful. It's just, again, something to think about. You'd be so surprised that you may watch this and think, oh, this is really never going to happen. You never come across a trust issue or a property titled in a trust where there's issues. Sure, 99% of the time, I don't know, maybe it's more like 96, but 99% of the time, nothing ever happens, right? Nothing's ever going to happen. And you're going to be able to close. You got the trust document, bring it to title, great. But it's those moments where there's issues with that trust. It doesn't clarify things. It happens more often than you think. Sometimes trust administration, all this court proceeding stuff has to occur because maybe the deed has an issue, but then that could be more quiet title. But maybe there's an issue with the way that the trust is titled, or the names all backwards. Somebody really messed it up. Somebody messed up the terms. There's been times before where there's been a trust and the estate planning attorney did their own trust, but they left out, like they just cut out, they did their own surgery on the trust. It cut out a major portion and it was all messed up, all jumbled, and it had to be fixed. Made no sense whatsoever. Ambiguity can be in there as well. Maybe sometimes a provision was added that needed to be. Sometimes there could be a provision that shouldn't have been in there. You never know. There's different ways that a trust administration could happen. And again, this is all because of title insurance when we're going over this. But this can happen not just with property. This can happen with anything, with IRA accounts or money market accounts, brokerage accounts. Maybe Charles Schwab is not releasing the money because the terms of the trust do not allow distribution until that person turns, and then it doesn't say anything, right? Like what if it says blank? You don't even know when that can happen. And Charles Schwab goes, we don't want to take the liability for distributing it to somebody at 30 years old when the trust was supposed to be at 40 years old. Things like that, terms can happen. But on the end that I'm discussing with everybody, it's more on the property side, about title on the property side. So finding leads like this, you get creative, right? Usually it's things that you pull, property data, records, there's so many different ways that you pull it. You can even find it on a tax lien, but usually these are just property records, right? So if these are kind of leads that you're looking at, you find it in trusts. Sometimes the property is already in the name of the trustee, so you bypass the trust. Now it's already in the trustee part. But trust properties could be really cool things to look at in terms of maybe motivated sellers, because you could be dealing with not just one property like in a probate. You could also be dealing with 2, 5, 6, however many they grouped in. There's just so many different properties and so many different combinations of what people could have done. And a lot of people do put property in the trust. They want to help preserve and do some kind of tax benefits. They want to help maintain wealth for their children as they grow. Sometimes they'll have 5 properties, but think about it. If they die, so their whole vision of buying this real estate and putting it in a trust, they put 10 properties in the trust, and then they name John, and John's now the trustee managing 10 properties. And all of a sudden he's like in his 5th year and he's like, I really didn't sign up for this. Like I didn't want to manage 10, pay the taxes, do the maintenance, collect the rent. I mean, after a while, some of these trustees, their perspective changes on why did I become a trustee? So you can have motivated sellers just behind these leads alone. And it's just really interesting, really cool to see some of this stuff. I always put this slide up here just because you never know how crazy some of these issues may be. Seen a situation before where there was a trust, there at one time was a trustee, and they died, and there was like 5 beneficiaries and they're all deceased. So it's like, okay, now what? And now they don't know where the trust is, but maybe there's some documents that they have, additional amendments and stuff like that. And so the question is like, what happens then? Like, what happens at that point? You got to make sure that the deal works, that the situation works. I hope I put the slide in there. I think I did. I think I'm coming across it, but there may be alternatives to this kind of situation where if you have it where it's so complex and a trust administration can happen because there's no beneficiaries, there's no trustee, who are you going to get? Who's around? And everybody's like, what do we do now? The deal has to make sense for everybody involved. You have to know what you're kind of going after. I didn't, I'm just backing up a second. So I thought I put it in here, but there are times where a quiet title could end up being a solution to a trust situation. So maybe the trust had deeded out to somebody. Now that one person's on title, but something in the back chain wasn't done right about the trust. So a trust administration is not going to work. Maybe the alternative, if there is a green light from the title underwriter, maybe a green light would be a quieting title, the ability to silence any interest that may be in the back chain. That could be a little expensive too, because you're dealing with multiple people that are deceased, multiple trustees that could be deceased. Just unique situations like that happen. But if you know what you're kind of going after with these, they're really different. They come up, but again, the whole point is to have the red flag and know that you have to make the deal. The deal has to make sense for everybody. So again, I'm Al Nicoletti. You can find me on Facebook. I'm here now. I'm sure you're watching it, or it'll be posted on the YouTube channel. You can also find me on my YouTube channel at Al Nicoletti. Tons of content. Drop your comments below. If you're watching this now or later, just share your comments, share your experiences, all of that good stuff. And, if you watched it all the way to the end, thank you so much for watching. I think, again, in conclusion, this is a really different topic, and you have to make it simple. You have to make it as simple as possible, because title insurance doesn't really explain this, right? Like a title underwriter is just going to parrot and repeat about, title, trust administration. They don't explain what it is or what you have to do or what you're looking for, really, because you just scramble to get a deal together that now you find out there's issues. So it's always good to work with the title company that you're working with up front whenever you come across a trust situation, and find out what you need to know about that. Do they have the trust? Do you need to give them anything, any of the documents that'll help them reach a closing? And so they come up, but this is a very different topic. Trust administration's a different world. And again, before I sign off, anybody that has a question about this, drop it in the comments section. If you have had an experience about it, please share it. Love to hear about it. And this stuff is different. So many people go through it. Some people don't. It's always good to share those experiences with others. So again, that's it for this session. I'll be back next month, and I'll probably either be doing probate or quiet title or something that will explain some of these weird issues that pop up at the last minute, that'll help either fix the deal or not salvageable, at least but we'll talk about some of those creative solutions to doing some of these deals. So I'll stop the share. Anybody has questions, again, drop them below, and I'll see you next time. All right.